I'm the only person speaking from Turkey, a kind of endangered species, I guess. I was asked to talk about lawyers and human rights defenders' situation in Turkey in 7 to 10 minutes, and I realized that it was impossible. So I decided to summarize what happened just last week, first in Turkey against human rights defenders, and then I'll try to summarize what is happening before the European Court of Human Rights and afterwards, because whether international justice is working about Turkey, we need to look at the most developed human rights system available in the world, Strasbourg, and unfortunately we will see that we can't get a lot from the court so far. Last week, 3 prominent human rights defenders were convicted in 3 different cases. These 3 cases symbolize what's happening in Turkey. So although it happened last week, if we did this meeting next week, we could talk about another 3 similar cases happening. So it's not just a coincidence that these 3 cases happened last week. The first case is about Mr. Ömer Faruk Gergerlioğlu. He was convicted on charges of making terrorist propaganda for retweeting a news story about the Kurdish conflict and the collapse of the peace process. Mr. Gergerlioğlu was a public servant, medical doctor, and he was dismissed during state of emergency. Later, then, he was elected as an MP for HDP, the opposition party, and he's the most prominent human rights defender at the parliament. Last week, his case started before he was elected an MP, but in an irregular way, courts continued the case even after he became an MP. And this is one of the discussions before judicial authorities, whether an MP can continue to be tried after the election. In any way, Court of Cassation approved the decision against him, and he received 2 years, 6 months imprisonment term. And now, if the parliament reads the judgment at the parliament, his immunity will be lifted, and he will go to jail just for sharing a news. This, by the way, this news is still online, and those who wrote the article have never been prosecuted for writing that. But Mr. Gergerlioğlu is an important person, not because of his routine activities, but he reported last December that female suspects and detainees had been subjected to humiliating strip searches by police in provinces across Turkey. His allegations were supported by a considerable number of prisoners who described their experiences of systematic sexual violence at the hand of the police. But Interior Minister Süleyman Soylu denied them and accused Mr. Gergerlioğlu of being a terrorist. And this is not surprising, I guess. The second case is from Istanbul, this time Eren Keskin. Eren Keskin was sentenced to 6 years and 3 months in prison for membership to an illegal armed organization. She was supporting Özgür Gündem, a pro-Kurdish newspaper, and she has been the maybe most courageous human rights defender in the country. As of June 2019, she had 122 different criminal trials. I'm repeating, 122 criminal trials. Until that date, she received 17 years, 2 months and 20 days imprisonment term and 359,000 Turkish lira fine for human rights activities. Finally, the third person last week received a punishment, not the only 3 person, of course, but leading human rights defenders. Şebnem Fincancı Korur, she's the current chair of Medical Associations Union of Turkey, Formerly, she was the chair of Human Rights Foundation of Turkey, a very well-known medical doctor. She was also punished for insulting the then prime minister during Gezi events. You might remember 8 people were killed and many others were injured during Gezi events. And Ms. Koru Fincancı criticized the government and the prime minister for this. And now she was sentenced to fine for criticizing him. So how can this routine judicial exercise can be stopped? Whether the European Court could be an answer. So I think we can follow up some recent judgments of the European Court of Human Rights. A lot of people complain a lot. Even I saw a comment in the chat box that the court is very slow and not always very keen on providing justice to the victims of human rights violations. But still we have some very important cases. One of them is about Alparslan Altan. Alparslan Altan was a member of the Constitutional Court while he was arrested. Some 3,000 judges and prosecutors, including 2 judges of the Turkish Constitutional Court and more than 160 judges of the Turkish Court of Cassation and the Turkish Supreme Administrative Court had been arrested and taken into police custody. Mr. Altan's immunity, along with other judges and prosecutors, was easily lifted by a very flexible interpretation of domestic law. Judges' immunity could only be lifted following a long procedure, as the case in many other countries. However, there is one exception. If a judge is caught while committing a crime that falls within the jurisdiction of the assize courts, then procedure to lift the immunity is not supposed to be followed. Alparslan Altan, as I stated, was a member of the Constitutional Court while he was arrested. So the plenary assembly of the Constitutional Court was supposed to lift his immunity. What happened? The local courts found that, first, the alleged offense of membership of a terrorist organization was an ordinary offense punishable under Article 314 of the Turkish Criminal Code. This is about the membership to terrorist organization, and thus falling within the jurisdiction of the assize court. This was the first condition. Then they said that this offense was a continuing offense according to the Turkish Court of Cassation's recent case law. But this case law was developed after Mr. Altan was arrested. Thirdly, in light of the very specific circumstances of the 15 July attempted coup, this constitutes the factual and legal basis for a case of discovery in flagranto delicto. This flagranto delicto is a Latin word which means that a person is caught during committing a crime. So, of course, Mr. Altan was not caught with a weapon, acting with the soldiers who attempted to overthrow the government. He was sleeping at home with many other people, but the courts held that membership to a terrorist organization is a continuing crime. So whenever you catch a person who belongs to a terrorist organization, can be called in flagrante delicto. So this case is important. Why? Because it was the first case about a judge where the European Court found that the Turkish government violated Article 5 of the European Convention on Human Rights. After him, in Bash versus Turkey, again, another judge, this time not a judge of Supreme Court, but an ordinary judge, applied to the court, and he also won the case with similar reasons. Now 600 other cases brought by judges and prosecutors are pending before the European Court. But what happened? The government and then the Constitutional Court stated that the European Court has no competence to interpret the domestic law. So they concluded that there is no way to implement the judgment. So both Mr. Altan and Mr. Bash are in prison at the moment. We're talking about judges and prosecutors. So this is critical. Who will provide the justice if you can't provide justice for judges and prosecutors? And I'm coming to another two important cases, and I'll finish there. But before then, I should also emphasize that recently in a couple of judgments concerning the journalists, the European Court decided against Turkey, including Sabuncu and others, Ahmet Şık versus Turkey, Mehmet Altan versus Turkey, Şahin Alpay versus Turkey. However, we heard the name of Ahmet Altan. He applied at the very same day when Mehmet Altan applied to the European Court of Human Rights. And in March 2018, the court decided in favor of Mehmet Altan. But after 3 years, he's still in prison, but there's no judgment, unfortunately, from the European Court of Human Rights. And finally, we're coming to two recent cases. These are very important because these are the first Article 18 cases decided against Turkey. Osman Kavala versus Turkey and Selahattin Demirtas versus Turkey. For non-lawyers, Article 18 is a provision about political detention or use of convention for political reasons. And it states that the restrictions permitted under this convention to the said rights and freedoms shall not be applied for any purpose other than those for which they have been prescribed. But for Osman Kavala and Selahattin Demirtas, there was an ulterior purpose, according to the court. In the Kavala case, to silence a human rights defender. In Demirtas case, it was to silence an opposition politician. However, the government, following the judgments in Kavala and Demirtas was a grand chamber judgment. It was a groundbreaking judgment, which I think summarizes the situation in Turkey about justice and explains how the judicial authorities abused legal notions to convict a leader which represents more than 10% of the Turkish society. But the governments responded first president and then the other high-level officials that they would not recognize the judgment of the European Court of Human Rights. They said that there is no way that those individuals would go free. And even in Demirtas case, when it was decided first at the chamber, the president said that they would take their own steps to keep him custody. And they really did it. Officially, the Turkish government is informing the Committee of Ministers of the Council of Europe that those judgments have been implemented because, yes, both individuals have been released in the cases examined by the European Court. But yes, what happened? Without physically leaving the prison, they were detained again. And in the case of Mr. Demirtas, he has been in prison for more than 4 years, and in Kavala case, for more than 3 years. Now, both cases are pending before the Committee of Ministers. These are very critical because the question is, how can a rule of law system can survive if the judgments of a court are not respected? Now we are at this level. Turkish government is resisting and claiming that it doesn't have to implement the judgments of the European Court of Human Rights. And unfortunately, politics might prevail over justice before the Committee of Ministers. On between 9 to 11 March, next month, not next month, 2 weeks later, both cases will be discussed at the Committee of Ministers. And the Council of Europe will show whether it really sticks to the principles that are founding for the international organizations, rule of law, human rights, and democracy. If we fail there, then I think laws like Magnitsky might be the next step and the question to force countries to implement international judicial decisions. Thank you very much.